I want to talk a little bit about a part of our law that's called tort law. And just very briefly, a tort is a wrong that's committed by one person, which could be a company, a corporation. In that case, we would call it a juridical person. But it could be a wrong that's committed by an individual human being or a corporation against another individual human being, or maybe several human beings, and maybe even against a juridical person, another corporation. The tort law requires two primary elements that apply to almost all of the intentional torts, and that is the act committed by the person who would be called the defendant if you went into court and had the injured party sue the person who committed the wrongful act. That person who committed the wrongful act would be called the defendant, and the person suing would be called the plaintiff. And I'll use those terms from time to time in this discussion. There must be a voluntary act committed by the defendant, the person committing the tort or the wrong against another person. And when we say voluntary, we mean, for example, that if somebody is asleep and they have a seizure during their sleep or a body movement during their sleep, and it hits somebody else that's in the bed with them, that's not an intentional, that's not a voluntary movement, so there wouldn't be no tort there. The same thing would apply with the requirement of intent. There has to be an intent to commit the act that causes the harm when a tort is committed. Today, what I want to talk about in this system of tort law is something that we are all familiar with if we watch the news or listen to the news. It's something we hear about daily, and this is what we call assault and battery. Now, before getting into the discussion about assault and battery, I want to point out that there are two jurisdictions in which assault and battery can be litigated. Number one is the criminal jurisdiction, where the state legislatures have formed or have fashioned laws that say it is a crime to do such and such, and if you commit this crime, the punishment will be such and such. That is criminal assault and battery, and that varies sometimes significantly from state to state. But there's also what's called civil assault and battery, and this is basically litigation that's non-criminal. If A commits an assault against B and no criminal charges are brought, B can still sue A in court for damages for the harm that was caused by A's act against B. That's what we're going to be talking about today, is civil assault and battery. Before getting into the discussion, I think it's important for all of us to understand that in a tort such as assault and battery, and there are two torts there, and that's what we're going to talk about today, there has to be cause and harm, and at the end of the day, a lack of a defense or a lack of a privilege to commit the act. Let's start with battery. What is battery? Battery is an intentional act that causes an offensive touching or contact with another person. So, for example, if A takes his fist and swings back and hits B in the nose, he's committed a battery, especially if he doesn't have permission to do that. Now, there is a case where one would have permission to do that, or where there would be a privilege to do that. And again, we'll talk about that shortly. But the point is, you have to have an intentional act. It can't be a seizure, for example, where somebody slings their arm and accidentally hits somebody else in the face. That is not an intentional act. That's an unintentional act, and it would not be a battery. And the actor who commits this intentional act must desire harmful or offensive contact when they commit the act. There has to be a desire to do something. You might even say to do something wrong, but there has to be a desire to commit the act. It can't be unintentional and still be a battery. Or the actor can be in a position where he knows substantially that the act that he's committing will cause offensive contact. And it has to be harmful. The act would be considered by the law to be harmful if the contact would cause pain, for example, or impairment of a body function, or if a reasonable person would regard it as offensive. So, for example, a fist coming into contact with somebody's face, or their nose in particular, would be painful. It would be satisfied on that point. It could break the nose and cause an impairment of a body function, breathing, but you wouldn't actually have to cause pain in the face, for example, to commit a battery. You could blow cigar smoke directly into somebody's face. And I believe that in most cases that would be considered to be an offensive contact by a reasonable person. So that could be a battery, even though there's no hard touching of the person. There's still a touching of the particles of smoke to the face of the person, and that would satisfy the requirement of an offensive contact. How about if I'm holding a puppy and somebody hits the puppy in my arms? They don't hit me, they hit the puppy. Would that satisfy the requirement of an offensive contact? I believe it would. If I had my hat in my hand and you snatched the hat out of my hand, that would be an offensive contact. I believe there was a case in Texas a few years ago where someone in a restaurant snatched a plate out of a patron's hand, and that was determined to be an offensive contact and thus a battery. There was harm, and the snatching by the offender caused the harm, and so we had a battery. How about assault? Remember, you can have assault and not have a battery, and you can have a battery and not have an assault. The classic example that I used to hear a judge use when I was practicing in another state was the example of a person throwing a brick at someone. Let's say you have Johnny and Jimmy out here in their neighbors, and Johnny and Jimmy get in a spat, and Johnny picks up a brick and throws it at Jimmy. Jimmy sees him do this and sees the brick coming toward him, and he ducks and the brick misses. Do we have a battery? No, we do not. Do we have an assault? Yes, we do. The requirement for an assault is that there has to be an intentional act by someone, in this case Johnny committed that act by picking up the brick and throwing it at Jimmy, and the intentional act has to cause Jimmy a reasonable apprehension of immediate harmful or offensive contact. Clearly, if the brick connected with Jimmy after Johnny threw it at him, there would be a harmful contact, and it would be offensive as well. But that is clearly satisfied in that case. Number two, the defendant, in this case Johnny, must have intended to cause the harmful contact. In this case, Johnny was not just practicing throwing bricks, he was throwing the brick at Jimmy. And that is enough to satisfy the requirement of intent. And there's no liability in these cases unless a reasonable person would experience the same apprehension. Well, I think that in a case like this, whether it's a fist coming at us or a brick coming at us that someone has thrown, there's a reasonable apprehension of an unpleasant or offensive contact, and even a harmful contact. If a brick hits you in the head, you've got a problem. So in this case, we have clearly an assault, even though Jimmy ducked and the brick missed him. And another little point here that we ought to make is that a lack of ability to actually complete the harmful act doesn't defeat liability. For example, if Johnny pointed a gun at Jimmy and Jimmy saw him do that and the gun was unloaded, didn't have any ammunition in it, we would still have an assault, because a reasonable person would assume that the gun's loaded if Johnny points it at him. And so in that case, we still have an assault. However, if Johnny throws the brick at Jimmy and Jimmy ducks and still is unable to avoid contact with the brick, and the brick hits him in the back, we have, or what do we have? We have both an assault. Jimmy saw this coming. He ducked because he was apprehensive. He wanted to protect himself. And secondly, we have the brick hitting Jimmy. And so Jimmy is able to sue Johnny for both assault and for battery because the brick hit him. These are interesting little distinctions that the law makes, but they're very important. What about if Jimmy doesn't see the brick coming? He's just walking along and one day Johnny throws the brick at him and hits him in the head, and that's it. Do we have an assault and battery? Well, in the criminal jurisdiction, we probably would. The criminal laws would probably define that act as assault and battery, or in some cases just assault, which would include the battery. But in the civil jurisdiction, in the common law, in the case where Johnny just throws the brick at Jimmy, Jimmy doesn't see it coming, and the brick hits him in the head and knocks him out, and he has to go to the hospital and incurs all kinds of medical expenses. We have a battery. Do we have an assault? No, we don't have an assault, because Johnny, when he threw the brick, didn't say anything to Jimmy. He just threw it. Jimmy didn't know it was coming. He was not apprehensive. He was not in fear of this offensive contact that the brick would make, and he got hit in the head. We have a battery, but we do not have an assault. An example of this is a case from probably 35 or 40 years ago where some people abducted a man and knocked him out. They castrated him, and the man survived, and then he sued the perpetrators, the people who did this, for assault and battery. The court found that there was no assault in that case because the man was unconscious and therefore could not be put in apprehension of this offensive contact, which was clearly offensive and would be to any reasonable person. But they were responsible for battery, so because they performed this offensive contact on this man, even though he was not aware of it. They committed the act, they did it intentionally, it caused harm, and the man suffered damages. And so we have battery in that case, but we do not have assault. And that's kind of the classical analysis of assault and battery. If you have any questions about this, please put them in the comments down below this video, and I'll try to answer them for you. It's really an interesting part of the law. Thanks.